Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another quarantine edition of Legal Bites. It's Thursday, the 9th of April, just a little bit before 12 noon here. And as I mentioned in my Legal Bites update from yesterday, trying to explain kind of where we were, as soon as we got a formal written update from a government agency that clarified everything, I would get back here and give you guys an update to clarify that. So as of about 15 or 20 minutes ago, you should have received from the Division of Real Estate, and every real estate licensee in the state of Colorado would have received this update from the division. It's an advisory that they sent out, or guidance that they sent out to all real estate licensees. And this was put together in conjunction with the Department of Regulatory Agencies, which falls under the governor's office, as well as I think the Attorney General, and their consultation and interpretation of the executive order that we've been discussing over the last really week, since there was a interpretation that showings weren't allowed, and then it got incredibly strict, and now I think we've settled on something that certainly works better than where we were over the last couple of days. And so here you have it. I'll just kind of go through it very quickly and then give you some of my thoughts in terms of how this impacts your guys' business. So the short of what they've said here is that real estate appraisals and closings are considered critical services to complete real estate transactions. Further, home inspections and final walkthroughs after a buyer has a signed purchase contract and is therefore a condition precedent to the actual transfer of a property is also considered an essential part of the real estate transaction. So as you guys know, there was some confusion, I think, between the AG and the governor's office over the last few days with the interpretation from the AG's office that, in fact, walkthroughs and inspections were not acceptable as part of the real estate transaction. And so this is clarifying now on a formal basis that walkthroughs and inspections, because they are subject to an existing contract, an executed contract, they are now a critical business. And so they're allowed during the course of a transaction, which makes a ton more sense than where we were, like I say, as recently as 24 hours ago. And so that's an important piece that you guys understand, that if you have a contract, you can actually allow the buyer to perform the functions that are necessary to get to the closing table, which has always been clearly an accepted piece of the transaction for everybody to be doing under the order. I just mentioned a couple of other pieces here. Elements that are fundamental to the real estate transaction are deemed essential to support market activity. However, showing a property or conducting an open house in person during the COVID pandemic shall be avoided, as it violates specific mandates of recently issued executive and public health orders. And so what that's saying is open houses and showings not allowed. Still maybe not where we were a week ago with the interpretations that had accepted showings. I was under the impression, certainly, and I think most of the marketplace was, cannot do showings at this point. And then there's a last line that kind of talks about further encouraging members of the public to engage in non-essential travel and or requiring residents to leave their residences for the purposes of viewing real property unnecessarily compromises public health by expanding public exposure. And so again, all of you should have received this. Every licensee in the state should have received this. And this is the division's guidance for real estate licensees. So where does that sort of leave us? I want to emphasize on that last paragraph that I kind of read, this concept of, encouraging somebody to leave their property. This is where I think we got into trouble on the original reanalysis of the executive order about a week ago. And, all of you guys have to be respectful of an occupant of a property. Presumably, if a seller is allowing inspections or walkthroughs or whatever, then they're not going to make any complaints or have any problems with that. But in a situation where you've got an investment property, there's a tenant in place or somebody else that may not be so cooperative and invested in the transaction to actually want to leave, that is going to just cause more problems as we're going forward if those sort of complaints surface through the Division of Real Estate or directly to the AG's office or anything like that. And so that's what that last paragraph is really getting to. And so the other thing I want to mention, and I've already seen some emails from our members and had some other questions, some of what I'll call more tertiary businesses, real estate photography for one. It's not addressed here. And there is a clear delineation between a real estate transaction function, which is the walkthrough and the inspection and the closing and those things that are done after a contract, and what appears to be delineated as a marketing service, and that would be the showings and open houses. And I sort of, my suspicion is that real estate photography probably falls in more of the marketing end of things. Again, this is not my interpretation. I mean, I'm not supporting this argument. I'm only giving you sort of my thoughts, because I'm getting the questions already. Here's my piece of advice is, if you've got a real estate photographer who's coming to you and asking you whether or not real estate photography is a critical business or can be performed under the governor's order, then I think your only response is, that's up to you. In other words, it's up to the photographer to make a determination if they are exempt from the order or not exempt from the order for their own business. And I don't like the concept that a broker or a seller or anybody else would be trying to interpret that on behalf of a real estate photographer or any other business, whether it's movers, contractors that might be looking at property for home improvements or remodels or estimates or whatever it might be. All of those other businesses, I've said it before and I'll say it again, I think you guys need to be allowing those businesses to be making their own independent determinations. What we know and what Carr worked on very hard to try and get originally was real estate transactions are exempted under the governor's order. Since then, that has, I think, been somewhat narrowed with regard to the showings and open houses not being a part of that. And what we've worked on really hard over the last few days has been to make sure that the AG and the governor's office and everybody else understands that it's just not practical for consumers or for realtors or for anybody else to say that inspections and final walkthroughs can't be performed in person. And so we have successfully received that clarification here, but we're not in a place to determine for the purposes of photographers or, movers, other tertiary real estate businesses, whether or not they're exempt from the order. So if a photographer is willing to go and provide photography services and your seller is willing to accept and allow that and provide access to the premises, ultimately that's the photographer that may or may not be violating the executive order. And that's up to them to analyze their risk and benefits for the purposes of that. I would say the same thing for moving companies or anybody else, staging services, any of those other tertiary functions that take place during a transaction. So do be cautious in getting sort of sucked into legal interpretation or providing a legal interpretation to some of our partners out there in the industry. Not saying that we don't support them and want to do what we can. It just is not as necessarily clear as any of us would hope. The other quick thing I'm going to mention is property management. I've had a ton of questions about property management, and that's gone on for the last few weeks. I'm left. Well, I would say clearly that under a separate exemption for sort of critical management functions, I think is how it's described. If a property manager has a tenant in place and the tenant has emergency or critical needs, like their heating goes out or hot water heater goes out, or there's a gas leak or any of those types of things, I think clearly servicing or managing those elements of a tenant's occupancy fall within there. The challenge that I think is the brokerage stuff, the leasing activity, I think probably falls under the real estate transaction piece. And I think in that case, my perspective at least would be that that showing a prospective tenant a property falls under the showing piece and not the transaction piece. So if there was maybe a lease in place that was contingent upon, or an executed lease that was contingent upon a tenant actually viewing the property, I guess I could argue that that would be part of the real estate conveyance activity. But if it was just a showing that somebody called and said, "Hey, I'd like to look at this apartment. Can you meet me over there?" Then different situation, I would say, because that's more on the showing end. And I had some questions about, can you provide a lockbox to a vacant apartment to a prospective tenant to go and look? And I think, to my mind, that's another place for you not to be analyzing. If a buyer is wanting to go out and look at property, or not a buyer, I'm sorry, a tenant is wanting to go out and look at property and access the property independently, that's something that they're going to make an analysis on in terms of where they fall within that order and their willingness to go out with it. So anyhow, those are what I know as of, like I said, just a few minutes ago. And you're going to be getting some additional written guidance from CAR. And like I say, every licensee in the state, realtor, non-realtor, whoever you are, you've gotten the update from the Division of Real Estate within the last half hour or so. So that's where we are as of the moment, and hopefully we have a little bit of static non-movement here, because I think it would be nice to have some clarity and consistency that we finally have and can sort of stick to that. So anyhow, guys, stay safe out there. We'll keep updating you through CAR's website, through the COVID portal, through these legal bites, whatever we can do to try and provide you guys with information and hopefully help you navigate some of the rough waters out there. So take care, and we'll talk to you soon. Thanks so much.